sleep peaceful when I'm out of sight.
Don't leave love unguarded. Don't leave hope unplanned. What you build in wisdom still stands when you can't stand. But it's stronger than you. Let it outlive your name. So the love you leave behind don't dissolve in the pain. If somebody gon' need come, let your vision remain. We don't just survive, we preserve the flame. Build it deeper than dreams. Let it echo through time. So young children know you planned every line. If the world try to take, let it be resistance. This is love and structures. This is legacy in existence. Don't it all love. Don't it all you. What you build in wisdom still stands when you can't stand.
State trust versus the wills versus the trust. But then this episode, we're going to dive into it, John.
Oh, yeah. We're going to talk about some details.
Right?
The depth of details that we're going to talk about today, you want to get your pen and paper together, take you some notes, call up some family members, send the podcast to them, whatever you got to do. Make sure you hit that subscribe and like button. It helps our algorithms. We want to make sure that we spread this message, this gospel, this financial gospel, as it's been called, the good news. The financial good news is that you can save on health care, you can save on taxes, you can avoid probate court, and you also can avoid frivolous lawsuits.
That's right.
And so there's a difference between state statutory type trust and that of federal trust. The question is, do you know what it is?
That's right.
We know that 95% of people in this country are going to go to probate court. Do
That's
you know what
number, y'all? 95%. John, so that's 95. That's only leaving 3 to 5% of the wealthy. That's why 3 to 5% of the wealthy run the country, because they avoid the probate.
Right. And so the question that we need to be asking ourselves, and the question you need to be asking yourself is, what are the 5% doing that I could do to do the same thing?
Wow.
Don't be mad, get glad, as I used to say.
Right.
Don't get mad, get glad. Get an understanding in all your ways. Get an understanding. Find out with questions of the right people, what exactly did they do or do they do to avoid having to pay so much taxes? You know, some of us in the middle class, we used to be upset at those people. Say, man, they don't pay any taxes. Why are we paying all these taxes?
Right.
People used to exclaim.
Right.
But the truth of the matter is that they know something that you and I don't know, because they've had teams of people to study it, to research it, and to come up with the answers that they need. And when you have good answers, that means you have good questions to go with good answers.
Well, let's get right into it, John.
All right.
This information is going to be for educational purposes, right? And for information. You know, you need to make sure you seek your own counsel. We do have in-house counsel. So you need to make sure you go, fact check on everything that we're going to talk about, because most of the stuff, I'm just right here on Google, John. It's just so easy to pull this stuff up, So when you look at state trust versus federal trust, what's the first thing comes to your mind? Because at first we didn't even really know the federal side of things existed, and a lot of people don't know. What was the first thing you thought when you first kind of heard state versus federal?
Well, I think of the Federalist Papers, as we said in our history. If you go back to the first episode we did about history of trust and wills in this country, you will clearly see that the states had and from the inception of their design and their development through time, you had the Federalist Papers. That means that every state could operate its own legislature in accordance to the development of its own laws. But those laws had to have some level of compatibility to federal law.
Come on.
And so, but the states were distinct because they actually represent themselves like a small country, and they have the compatibility. So the thread between all what makes it united and the United States is the Federalist Papers. And you can go and study in the history of Federalist Papers, what makes a state a federal, what makes a state its own entity, and state sovereign rights
incorporated,
as opposed to that of the federal side. So now you can understand more when you look at that piece of history. Things are the way they were, so that things are the way they are now because of that history. So now we can see in the history that states have their own statutory laws, all 50 of them, that govern what happens in their borders of their state.
That's right. That's what it says right here. It says state trust versus federal trust refers to, trust, how the rules that they're governed by. And it says right here, state laws have their own sets of rules, right?
Right.
And federal laws have their own sets of rules. Now, what's interesting about this is that we know that the federal is over the state. So if you end up picking a state trust, then you are being double regulated. You're being double governed.
Right.
In some cases, you can be double taxed.
Right.
Okay? Because you had to adhere to the state and the federal.
Exactly.
And that's, again, it kind of makes it confusing for a lot of people because, most people only think that their trust can be only in a state jurisdiction. Well, we're coming to find out that basically the trust can be in another jurisdiction. So just to kind of make things in clarity on everything, when we talk about state versus federal, we're talking about the sets of laws that they're governed under, right?
That's correct.
Right? The sets of laws they're governed under. And then we're going to have to see what actually determines that. All right? So now, tell us about Washington, D.C.
Well, Washington, D.C., as you well know, and as some of you in the audience, Washington, D.C. is called the District of Columbia. That's what the D.C. stands for, the Washington, D.C. Now, some people in the Maryland area actually perceive or think that Columbia is going to become at some point in time, become its own state. Well, let me tell you right now, if it does, it's not going to have anything to do with the District of Columbia. They would gerrymander that city around. I don't care if it's a little piece of land left. It's going to still be called Washington, D.C., because that is the design of a country. In order to have a federal government, you got to have a place for the federal government.
Right.
And the District of Columbia in the United States is the place for the federal government. So that district that was laid out and remembered, according to Benjamin Banneker, remember the whole blueprint of the layout of Washington, D.C. when it was burned down to the ground. At one point in time, the White House and everything like that.
How they laid the entire city out.
He reconstructed from memory.
Come on.
Because even the blueprints and stuff were
Burned out.
all burned up. And Benjamin Banneker went in there, and with his photographic memory, it was said, yes, an African-American man who had the ability to reconstruct the entire layout of D.C. And that's why D.C. is the way it is today, in its layout of its structures, of its all this. And of course, it was done a lot of it by Freemasonry.
Right.
Many of them were Freemasons in that early years. And so that's why the constructs of the obelisk and all that with the, you see the Washington Monument and all of that is all laid out in Freemasonry. But the whole city itself of District of Columbia, in order to make the laws for the states, you have to be, as you often say in the podcast, you have to be not in the state to make those laws.
That's right.
Well, technically, District of Columbia, that's why it's called district, because the district, though surrounded by a state, and it's in the jurisdiction of the area, it is not considered a state itself. It's considered an entity. And so that entity is able to make federal laws for all the other states.
So to add to that now, the District of Columbia, or Washington, D.C., as you call it, has its own bar.
Right.
See? And a lot of people don't know that. Right. The district itself has its own bar. And like I said, we all thought the 50 states had the bar. You had to get a state bar. But Washington, D.C. has its own bar. Can you believe that? And so the question is that, if it has its own bar, then can an attorney set up a trust under the District of Columbia? And that's the question.
Right.
Can your trust be in the federal District of Columbia? Well, let me answer that for you. Yes, it can. Okay. When did we determine that? When did we find that out? That information has been held from us because they want to force, like you said, 95% of the population to go through the state. So again, the federal government ain't got to deal with the whole population, right? We'll put all the rest of it off to y'all, the peasants off to y'all. We'll deal with the wealthy, hoity-toity people that's doing things international. And that's really what it is. The federal district is for a district that people doing things, in the country, but mostly around the world. And that's why you see that all the major, these major institutions are in that 14-mile radius when it comes to all the government buildings, all these other different type of buildings that, have the international presence, like the IMF, building, the United Nations buildings are there. So you see what I'm saying?
Oh, yeah.
They're operating in other districts and other parts of the world. But it's interesting that they're governed in the jurisdiction of the District of Columbia. Okay?
Right. And that's why you have every state that has a governor. A governor is like the president of the state. And that's the position. And the legislature of that state is like Congress, and the Republicans and Democrats that makes up the various represented districts that is carved up in their states. And as you know, recently with all the gerrymandering, different approved maps and so forth, that's how they represents themselves, not only here in the district of their state, but also a representative from there that also may be represented in Congress as well.
Right.
So you have that.
So let's talk about these states. So this is state trust versus federal trust. So it says right here, Google, that some examples of state trust are living trust, testamentary trust, Medicaid trust. Okay. These are all state-driven type of trust, right? And they have their provisions, but they also have their disadvantages as well, right? What it also says about state trust is basically they're under the governing laws of that particular state, and basically every state has its own set of laws. So when you're actually looking at your assets, you got to make sure that you're actually in correspondence with those states. Okay? Now, what kind of limitations do state trusts have?
The state trust limitations generally is because they have their own set of laws that govern, and all the attorneys that set those trusts up in their state, they set it up according to what they're legally allowed to do under their bar license for that state. And so if you go to an average attorney and say, hey, can you set me up with for example, a federal private trust? He's gonna look at you like kind of crazy. Like, no, I don't do that. What you mean, a family trust? And they say, yeah, family trust. And they set you up with a family trust.
Right.
Not knowing for the person that you're getting a living trust from that state. A living trust is going to have a commingling with your social security number. And if they give an EIN number for you, then they're going to have an EIN number with it. Now, we understand that there are sort of like two different types of living trust types.
That's right.
That is considered to be grantor and non-grantor type. And what are those types differential, Russell, between?
So when you're looking at the state trust, there could be a revocable living trust.
Okay.
And that simply means that basically, it's a grantor, revocable living trust. Your social security number is attached to it. Really no need to open up a bank account because your assets are never going to be separated, y'all. And that's where the illusion of protection comes. When you think you got some protection, you really ain't got nothing, because your personal assets still sitting on your 1040 tax return. Okay, that's why you don't need a bank account to separate the affairs, because it's still in your social.
Right.
The second living trust is when they basically say, okay, we can do a non-grantor living trust, which means basically they use a settler to actually establish the trust, and then basically they choose a fiduciary like a trustee to manage it. Okay, but it's still a living trust. Right. And the only thing you can do with that basically is only going to activate at the person's time of death. Right. So those are the two type of living trusts that they're making and forcing you to operate. What if you can operate with a trust that basically you can benefit from your actual trust in this lifetime? And that's what you can't do in a living trust. Okay. Now, those living trusts are designed to take money out of it. We talked about Medicaid. They got a design special type of trust just for if you want to avoid Medicaid, called a Medicaid trust. Right. And those are all statutory trusts. So most people only know about those type of trusts. Okay. So the state trust, one of the limitations is that basically when you set it up, you can't add nothing else to it.
Right.
So, I'm like, wow, what about my next generation? I can't add nothing else. So that means if you buy a house today and you set your trust up, and then you turn around and sell your house and then buy a new house, do you got to get a new trust?
Answer the question. Well, that's why they have an overpour will. An overpour will is that anything that is not contained in that trust will spill over to that of a will. And so there are hardly no state in all the 50 states that a lawyer sets up a living trust for you that he's not going or she's not going to attach a will to it. No. Now, many people actually think that they don't have a problem with that because we're used to and culturalized to understand that wills. We're taught that all our lives. Our parents or grandparents may have had wills. And so that cultural understanding has been passed down to us. And it's not necessarily wrong that that's what you know, but there is something different. There are different choices and alternatives. If you have a will, as we learned in last week's program episode, is that you got a first class ticket front row seat to probate court.
That's right.
If you have a will, you have a living trust in a will, or you have intestate, meaning that there are laws that are designed that if you don't set up a will, you don't set up a trust or anything at all in your lifetime, that you die without having any of those instruments, you're now called an intestate kind of a case. And so those are laws that each of the 50 states also set in place so that if you die without that transition and those documentations, then of course they step in and they are able to send you to probate court to get titles of land, heirs property, whatever the case might be, that now falls under their jurisdiction.
Wow.
So with that in mind, the state then has jurisdiction over your particular estate. Do not kid yourself, and a lot of people do, just because you can shake hands and walk out of that lawyer's office and thinking you got something because you got a living trust now and a will, and it sounds like so thoroughly complete. But there's one key word there. Most of the time it's revocable. And the revocable nature of it says that I haven't really made up my mind whether I want to be in charge of this trust or not. So the acquiescing or the transfer of authority then goes to the attorney to suggest that, hey, we're in charge then. The law firm or the lawyer is in charge of that estate in terms of making decisions. And just because a person in that living trust and that will is given the power of attorney
Doesn't mean anything.
and the medical power of attorney to make certain financial decisions if the person becomes incapacitated or the person, something happens to them when they cannot take care of their responsibilities while they're living, that's one thing. But when the person passes away, the power of attorney is gone.
Disappears.
And the medical power of attorney is gone. And the only thing left now is an executress of the will. That
Or
could
trust.
be anybody. That may not even be a family member. And that's an objective person to see that the fairness is carried out for that particular type of will document, living trust document, and will. That's what it's for.
Right.
However, that doesn't mean that they're totally in charge of the decision making.
Right. That's
They've
right.
got to collaborate with the attorney that has been appointed by the judge or was the attorney of record for the one who set that document in place with the original person who signed that document.
So basically when, the person passes away, the living trust becomes irrevocable.
Right.
See, it starts as revocable, but as soon as you pass away, it becomes irrevocable because at that point in time, everything has to be distributed out of the trust in the living trust. You got to be taken out. So I mean, everything has to be done through a trustee and executor. Now, once that's done, your legacy is over. Okay, that's why it becomes irrevocable after that because it's done. Once you pass away, there's nothing can be changed after that. However you had it set up, people are going to receive those distributions. There's nothing you can do without it. And that's why the attorney comes in play.
Right.
Because they got to oversee that to make sure you as the executive did it right.
Right.
And anybody come making a complaint, then there comes the actual lawsuits.
Right.
See?
And that will is what gave them that access.
Exactly.
That's why they attach a will to it. And when
The
I talk-
overboard will to make people look into the social security number of the person. Just at one glance at your social, now they can bring in all the creditors in that overboard will. Wow.
Absolutely.
Huge. Now,
And they make money out of that.
that's exactly
That's
right.
their legal engagement with the will. If you didn't have a will and you didn't have a living trust with a will, now you have you've taken again the hound, the fox out of the hound's mouth.
That's right.
Because now you've made a situation where if it's a federal trust that has its own EIN number that's filed with the government and not registered with the state, that takes the revenue out of their hand because you don't need a lawyer with a federal
At the
trust.
time of your death now.
At the time of your death. You don't need a lawyer.
You don't need nobody, refereeing.
You don't need no probate court. And it just goes right to the family the way you designed it to go to. or it goes to being in charge of a person who is the compliance officer, successor compliance officer, or successor trustee.
Right.
And it's their discretion as to what gets paid out, what doesn't get paid out, or who gets the distribution, who doesn't. And that's the way that you contain how your trust is going to build generational wealth.
So people ask then, well, how do you put a trust into the federal jurisdiction? Because, when people say federal trust, I want to make sure we understand what we're saying here. We're not saying that this is a trust that the government created.
Right.
Not saying that. Now, the government has its own set of trusts. They got Social Security trust. They got Medicare as a trust. They operate in trust, believe me. But we're not talking about a trust that the government created. We're just talking about the jurisdiction of the trust. Okay? So people say, well, how do you make sure your trust is in the jurisdiction of the District of Columbia? That's a very interesting question because it's not just one factor here. Actually, it's several factors.
Okay.
John, what's one of the factors, man, that you got to make sure? If you say that your trust is in the jurisdiction, because we talk to some people that say they do trust, we just let them talk, right?
Right. Just let them talk.
Let them talk, and so they reveal to you how they do their. Oh, I have a federal trust, but what did you find out about after you talked to the gentleman? What he said he did?
Well, what some recent gentlemen. So if you say that I have a federal trust, or we set people up with federal trust, but you put the jurisdiction in the state of their residence, and I asked you the question, I say, well, where's the jurisdiction? And you say, well, it's a federal jurisdiction. I say, well, where's the origination though of the design of the trust itself? The address. What's the address of the trust? And he says the address of the trust is either the place of the business who designed it, or it is the address of the resident of the person who has the trust. And I said, that's interesting. I say, and that gives it federal jurisdiction? I say, how does that give it federal jurisdiction if you just gave the address in the place of a state?
Come on.
You stated that it was a federal trust, but the documentation shows that it's a state statutory
Address
inside a state statutory jurisdictional control. So how in the world is that going to be a federal instrument when you have a state statutory instrument that's at the helm of the governance of your trust? Therefore, you don't have a true you don't have a true federal type of instrument here. You have a state statutory instrument that's been named federal, but in actual functionality, it is actually statutory.
Come on, Doc.
That is an illusion of security, but no real security itself. That is the appearance of federal, but actually, when you dig through the whole minutia of all that, you discover that it's only a statutory trust that's named a federal trust. And naming something and claiming something does not make what it is if it isn't.
Because FedEx is not, they're not owned by the federal government.
Right, exactly.
Oh, exactly what you're saying, right? Okay.
So like, unless that trust, you listen to me very carefully, y'all. Those of you out there who have state statutory trust that have been set up by an attorney in your respective states, let us just share with you the P.O. box, the post office box. Post office box is attached to the EIN number of a federal trust because the post office in your city, county, state, and your parish, if you're in Louisiana, is associated with a federal jurisdiction, and it's in a federal jurisdiction because it's an extension of Washington, D.C.
So look, you got the signs on the window say, hey, you better watch out.
Right.
You're not in state statutory land anymore. You're walking into federal jurisdiction. You better take them guns off. That's 20 years federal.
Yeah.
You better not get in a fight with nobody inside the post office because they don't have misdemeanors. It's all felonies. Y'all get that? Because you're in a federal district. So when you walk into that post office, we're not talking about a UPS store. We're not talking about a FedEx box. We're not talking about Regis virtual address office. Because I heard them all, man.
DHS.
Right. You can't look. The only one that's owned by the United States. United States is the United States Post Office.
Right.
And so, John, you're very right, man. If you're at, when you're getting your EIN number, and by the way, what's interesting about that is that you can't use an EIN. You can't use a P.O. box to get a business.
Right.
The IRS, they say no.
Right.
Can't do that. We need a physical address. Same thing with any other nonprofit entity. You got to have a physical address. But for some strange reason, when it comes to getting this irrevocable federal private trust,
It's permissible.
they allow, listen to me, y'all, you just putting P.O. box. You know what's interesting about it? After you put a P.O. box in the state, they whole version of your P.O. box comes up because it's already in their database because they own it.
Right.
So you want to use your version or our version? Oh, we just use your version because you already got it already in the database.
Right.
And they take the P.O. box for your trust. Can you believe that? Interesting. So jurisdiction is number one. So when you say, hey, I have a federal private trust, how do you prove jurisdiction? See? So we just talked about number one, the P.O. box. Number two, your trust documents have to specify what jurisdiction your actual trust is in.
Right.
The documents itself.
The location.
The location. Where is it at? And most people, like you said, jurisdiction, they're putting it into a state.
Right.
And we asked the gentleman, what'd you ask him?
I asked him what state. I asked him where is the jurisdiction of your trust, and he said state of Texas. Now, if that's the case, if it's the state of Texas, and he's not wrong on. I mean, he's not wrong on what he's trying to do, attempting to do, but it's misinformed.
Right.
And the misinformation is that there are 9 states in the United States that are common law states.
That's right.
And 41 states who are income tax states. And so the 9 states, and that being Texas as being one of those, and then of course Wyoming and some other states in the United States that are of those types of fit that characteristics, including Delaware. But the fact of the matter is that, well, Delaware is questionable with Delaware, but the fact Nevada, Florida,
yeah, Tennessee.
The fact of the matter that these states are jurisdictional states that are common law type states does not engender them to be federal style, federal property, federal mandated states that allows your trust to have federal status because you have put the federal status in the state of that residency. That means that state laws governs
That's right.
the jurisdiction of that trust.
That's right.
And that the lawyers don't have to go to D.C. to do anything. They just call you and haul you into locals
And
state court.
I think you're right. You see, what you just hit on something that the common law of the federal government, is basically saying, well, because these 9 states operate under common law, yes, they might have similar laws, but they also have their actual own legislation. Am I right?
Right.
Huh?
Right.
They have their own Supreme Court inside their own state. Am I right?
That's correct.
So even though they might, the federal government is common law, and the state might be a common law state, they still have their own sets of laws. And when you do that, like John just said, you just gave the jurisdiction to the state. That means any state, a licensed attorney can now come up against your trust.
Exactly.
Now, the only problem with that is that the state allows accusations.
Exactly.
Man, what the problem with that is that I can go right to an attorney right now with some untruthful information. The attorney is not going to get prosecuted for what you tell him. He's just able to act on what you tell him.
Right.
So it could be a complete lie. As long as you pay for that, you now have a lawsuit sitting at your door. And see, that's playing with fire to me.
Oh, yeah.
And that's nowhere you can say that basically you have any type of actual privacy when it comes to your trust. So state trust, y'all, another thing we need to know about that is that most of them are registered with the state or the county that they actually were created in. And why do they have to do that? Well, if the attorney's ever going to have jurisdiction over it, they got to have it registered. And they got to know the county that they was put into, right?
Right.
And so those trusts are, again, in a county record. So if you know the name of the person that might have set up that trust, like your last name is Washington, and I know what county you in Tarrant County.
Right.
I can just go freely one day and say, man, let me just go check Tarrant County public record. Say, hey, man, has anything been filed under John Washington? Get his name in. They have a database. And with AI technology now, I mean, bam. Oh, yeah. It was something filed about 6 months ago. Can I make a copy of that? Yeah, it'll be about $38. Here you go. Right? And now I got a copy of your trust.
Right.
How private is that?
Or at least that it exists.
That you at least know it has one.
Right.
And so now you can see how much confusion that can cause because it's in the federal in the state statutory land. Now, another thing that kind of gives the jurisdiction of Washington, D.C., we talked about address, we talked about the paperwork.
Right.
What about the bank?
The bank. Interesting thing. Some banks do some weird things, and I'm just going to put it on blast and just tell you.
Well, John, tell them first about, the bank has basically, so you're telling them what jurisdiction that the trust is in.
Right. When you go to a bank that want to succeed trust, you're gonna have a trust certificate. You're gonna take that trust certificate to the bank, and along with your EIN number, having been filed with the IRS. Those two documents for these types of banks, that's all the documentation you need. If you go to any of the other banks that are more or less geared towards state statutory types of trusts, they're going to ask you for all the documents that you have that's associated with that particular trust. And so the banks that we know of that do these particular federal trusts are Wells Fargo, Truist, PNC, U.S. Bank, and also Frost Bank, and some Navy Credit.
It's some other banks out there. Those are not the only ones, y'all.
Yeah, there's some Missouri Bank of Missouri, and then I think the Red River Bank of Louisiana, and a few other banks that's probably more than 100 years old or plus.
There you go.
They can do some of that.
To it.
Right. However, in the area here in Texas that we're in, residing in this state, and other states that are like it, because this is for, throughout this podcast it's interesting for you to note and be very careful to pay attention to your paperwork, because something here that came to our notice recently, and I want some of those of you out there who have Wells Fargo accounts, and I'm talking about disparaging any particular jurisdiction, but this has been put before them and asked to them legally. How is it that sometimes you have to observe that when a person is saying that your trust, it cannot be put in a P.O. box. So they take the trustee.
The physical address.
Okay. Cannot be at a
P.O. box. They saying the bank is telling you that.
Right. So they try to put your stated address as being the location of your trust. Now, to the credit, I have to say, to the credit of Truist Bank, they don't do that.
Wow.
Right? But to the credit of Wells Fargo, would put to the test so far. They're still going through some legal wrangle-tangling about it right now. It has not been settled yet, but there is a notion that they tend to put, or try to attempt to put, clients' location of their trust in their state according to their physical address, the driver's license and physical address. But that's inappropriate, because the first thing that you ask them, and they ask you, is that where's the jurisdiction of this trust? And they have it documented right on the computer, the District of Columbia.
Right. It's not Washington, D.C., y'all. Make sure it's
not Washington State.
District of Columbia.
Yeah,
that's right.
We're not Washington State.
Right.
Because you just say Washington, they're going to assume it's Washington State.
Right.
Because remember, even the banks, for the most part, they're acclimated towards state statutory trusts. So if you say the jurisdiction is in Washington, when they pull up on the screen, it says Washington, the state. But you have to be specific, because if Washington, the state, Washington, D.C. may not be listed, but instead District of Columbia is listed. So you have to tell them specifically District of Columbia.
That's right. That's right.
Now when you say that, now it's properly placed and documented. But then you're going to come back and say, the jurisdiction is District of Columbia, but I'm going to make sure that your trust gets placed at your home address, the location of it. So what we do with our clients then is we let them know that the post office, the physical address of the post office, is the location of your trust. And you know why? Because that is where the location of your trust is. It's at that P.O. box. That's why. And it ain't in my mailbox in my house.
So what happens is, like, if you have two trustees, right, and they got different addresses, then whose addresses is the bank using? See?
Right.
And that's what to your point.
And I asked that question.
It's saying, well, which way you gonna use? Because you say that, so it doesn't make sense of what you're saying.
You can't make it up, Russell. Right. I asked
and that
representative
your point. Yep.
Of that question, and his response to me was, well, I'm not sure, but we got to make sure that at least one of the trustees, that the address is located at their.
That makes no sense.
And I shared with him, I said, so that in a lawsuit, when the judge asked the initial question, where is the jurisdiction of this trust? And you guys are a party to the lawsuit. What are you going to say? And he looked at me and says, that's an interesting question. I said, because if you're going to say to that judge, according to your own records and documentation, that this is a federal jurisdiction of District of Columbia, when he asked you what a jurisdiction is, but yet and still the stated location of the trust is in the registered state,
then you got an issue.
then we have an issue here.
That's right.
Because you're incongruent with your own policy as saying that this is a District of Columbia trust, federal jurisdiction on the one hand, and on the other hand, you're placing the location at my residence along with me being,
and by the way,
possibly the trustee as well.
John got a chance to talk to some of the high execs in Wells Fargo. And, because of what we asked them, they kind of looking over that information. Now, Wells Fargo has over 100 attorneys. They've seen our trust, they know about our trust that comes through there. But it's very interesting now that we challenge that and see what they're going to come back and say. Okay? Now, the last thing that's going to actually make sure that you have the jurisdiction of, the federal district is basically making sure that you have an attorney that's licensed in that.
Oh boy, there you go.
District. So it kind of makes it hard for people that say they do federal trust and they don't have an attorney in the federal district.
Ooh, well, you said a mouthful there.
So we're not attorneys.
Right.
And we're going to make sure that everybody understands that. But what Succeed did was we made sure we hired an attorney that works in our actual firm that's licensed in the District of Columbia. Okay? So she draws up the documents, and she's the one that actually signs off on your documents. Now, when it comes to when the jurisdiction is going to be questioned, we have 4 distinct things that actually classify jurisdiction.
All right, go for
You
it.
see what I'm saying? So we got the address, we got the trust documents,
Okay.
we got the bank account,
And
we got the attorney.
there we go.
That's it. That's it, y'all. And so
And
you got to be very careful about all these people that say they got federal trust if they don't have them 4 things.
Say it again one time for emphasis. Say it again, Russell.
Address, trust
Which is the PO box.
which is the P.O. box.
Uh-huh.
From where? The United States Post Office.
United States Post Office.
Not no other P.O. boxes. There's so many P.O. boxes out here.
Right.
Other different types of boxes, but it has to be United States Post Office. Then you got to have your trust documents to state that it's in the District of Columbia. It has to be in your trust documents, okay? Then when you go to the bank, like John said, if they put Washington, you in trouble. They should be putting District of Columbia. As you can see now, everything is consistent. The P.O. box is in the District of Columbia. You got your documents there. Now the bank's references the same thing. And the last thing is that attorney, come on, better be licensed in the District of Columbia, because that's the only way you can defend anything that comes against that trust.
There you go. And we've run into situations where attorneys were literally, they had, they didn't have a federal attorney. They had a state attorney. So what that led me to believe is that their marketing campaign of their trust is geared toward state statutory attorneys who are not going to be bothered with traveling to D.C. because they want to make sure that those instruments are tied to where they can have access to being the attorney in that state.
That's right.
So that's the subtlety of putting it in the jurisdiction of the state itself.
Well, the question might come up and say, well, why do we need to put it in the federal district versus the state? What's the major difference? So John, what do we think the major difference is you put in the federal versus state?
The major difference is the EIN number versus the Social Security number. That's one of the major issues. Because if you put it in that Social Security number and you register that document with the state of your residence, you are now in the state statutory jurisdiction. And all they have to do is look at that 1040, which is a federal instrument, but also it shows all your assets and stuff there. The purpose of having a federal trust in the first place is to have your EIN number where you have the protections of privacy in there. And of course, privacy is a growing, very interesting word in an AI community and AI society.
Come on, better talk about it.
Where, and we're going to have a podcast where we talk about privacy because we have to.
Public versus private. That podcast is coming.
We almost have to, because The
Because
fact
people don't
of the
really
matter
know what it is.
You got AWS, you got Siri, you got Alexa, and they're hearing all your conversations in your household, in your privacy of your household. So where's the privacy in that? You telling all your business. You think you have a private conversation with your spouse about your estate, about all your stuff, and Siri is right there listening in on everything.
And that's
what I just learned this the other day, Russell,
what.
that they have the ability through your TV, even though it's off,
Come on, Doc.
they
And
can
your
use
computer,
they can use the
heard that.
mechanism of the speaker to two-way hear conversations in the room back through the TV and back into devices that can capture the information that you're saying in your room. So when they want to go after you, oh yeah, they can go after you. They can make attempts to pierce corporate veils. And so that's why sometimes some people go rogue on trying to be very careful in their privacy.
That's why that conversation, your documentation gonna beat that conversation. See, AI and all them and all that, they can't read that paperwork in that trust private bonder book. You see what I'm saying?
Right.
And so your paperwork, y'all, has to speak for you. Listen, when you gone, who gonna speak for you?
Mm-hmm.
That paperwork. Did y'all hear me? The paperwork is gonna speak for you. That's the only thing that's gonna speak for you. And that's why that paperwork gotta be in order. So it's not just about saying, hey, I want to set up something. If that paperwork is not set up and is not signed, sealed, and delivered and notarized, it means absolutely nothing.
And that's a good point, Russell. That's an excellent point. You know why it's an excellent point? That documentation beats conversation.
Right.
Because you look at the Bible, y'all. Something that Paul wrote, Peter wrote, James and John wrote, the Synoptic Gospels wrote. They wrote that material nearly 2,000 years ago.
Come on.
And it's in the standardized Bible today. And before that, the prophets wrote. The prophets wrote before that.
Come on, Doc.
1,000 years or so before that. So you have the survivorship of the written document of thousands of years of documentation beating conversations. Jesus stated it best and said, John stated it best and said that if all the books that could be recorded of the activities and things that Jesus did in his 33 years,
Right.
that there would not be enough books to contain the documentation of the information of this brother's testimony of what God did during that time period. And so we know that through history, it has proven itself that the book, that the written material is more powerful. I don't think a CD, I don't think a DVD, I don't think a jump drive, I don't think a computer imaging, I don't think none of that stuff digitally would have survived for 2,000 years. Do you? I don't.
So.
I mean, these things were packed in scrolls and protected with various chemicals of their day to preserve those documents over the years. And it was so prolific of the documentations and the monks who were repeatedly writing down in the scrolls and putting it in and protecting it and so forth, because it was so precious to them, because that was their social media communication to the next generation. And so that's why these trusts are so important to be written. I love the Yul Brynner in the book of Ten Commandments where it says, so let it be written.
Right.
So let it be done.
So, man,
so let it be written,
man,
and so let it be done in the documentation, in the notarization. So let it be written, so let it be done. There you go.
And so when you talk about these federal trusts, and the reason why you're saying that is because a state trust is over after your life.
Yes.
You can just might as well throw the trust book away. You see what I'm saying?
Right.
But this federal trust is going to continue on.
Right.
And that's why it has to be preserved. And again, the federal trust is the way to go. You listen to me, y'all. We're not building legacies around a state border.
A state border.
If you're going to tell me you're going to stay in the state of Texas and then all your kids, you told them, hey, you better not move out of the state of Texas. Everybody in my generation better stay in Texas. Then maybe I'll agree with you that you need a state trust. But are we able to control that? Everybody's kids now are in different states, part across the country, across the world. If you need to protect their assets, you got to have it in a federal trust. There's no other way you can do it. Okay, so we've learned that, right? You know, my time at Coca-Cola, you know, taught me that hey, they're operating in trust. They're one of the biggest companies in the world that's recognized in the world. They are a billion-dollar company. How and where? How are they protecting their assets? You know, one of the major things that used to happen. People used to try to stop so fast and so quick to get hit by a Coke truck. Not understanding the trucks ain't even owned by Coke.
Wow.
All you got is a policy, brother.
Right.
That's it. But you think you about to get billions
Right.
because a Coke truck didn't hit you. Man, boy, they protected themselves because, man, they understood protecting their assets, right? And so you can't get nothing from Coke. Can y'all? Not one thing.
Right.
Just the insurance policies that they carry. You can't. That's a federal side trust. And do you think that Coca-Cola is going to let any state attorney come up against them?
Right.
They're just going to let any state attorney.
Sure.
Nah.
And then you have Elon Musk, and you have the electrical cars, electrical vehicles now as well. I mean, can you imagine a police officer stopping a allegedly electrical car that might be speeding and get there and say, who's the driver here? Who's responsible for this electric car? Where you going?
Right.
Maybe you have to talk to the computer. Maybe there's an electronic hand that comes up at the window and say, talk to the hand.
Right.
Anyway, I'm just teasing.
So state trust, y'all.
The fact is that, yeah, you have, our society is changing, y'all.
That's right.
It's changing.
Right.
And still the old rules.
Yep.
Documentation still survives, and you want to make sure it survives in the right jurisdiction.
So last thing we're gonna end with is, we like to use real experiences here. We had a client that had a state, what was this? A living trust, just a living
with a
trust
will,
with a will, overpour will attached to it.
Right.
Okay, so one of our clients that purchased one of our trusts revealed this information to us, and I could not believe what I was looking at. So, long story short, John, an uncle, man, what a good uncle, man, left $28 million. Now, this is what we found out. So he had a wife, but he had no kids, right? But his sisters and brother was deceased, so the last people were left with the nephews and the niece. So, wife, nephew, niece. These were the surviving, supposed to be the survivor for over $28 million.
And the mom, right?
Well, the mom, the wife, the wife is the one that was married to him. They just didn't have any kids.
Right.
So, and then the brother and the sister that he had were already deceased. So they just had surviving kids.
Right.
Which were the niece and the nephew.
Okay.
John, tell me how much money was extracted out of a $28 million estate.
We had 10 million. That 10 million went to the lawyers, and another collective 8 million went to the state, because the state of Ohio has a state income tax. So the state of Ohio and the federal took their share of the taxes. So between the state, the federal, and the lawyers, they took $18 million and then lost about $1 million of it in the stock market. The lawyers did in that 6-month time period, somewhere around there. And then you have, of course, their expectation was to get 4.9 million apiece.
You're talking about the niece and the nephew.
And the nephew,
right?
4.9 million. That was
So
the expectation.
you think it's a $28 million stake? So you just said the wife got 10 million.
Right.
You think that out of 18 million left, they would get at least
Right.
You even still giving grace by saying we take another 10. You're giving y'all 8. That still should be enough here.
Right.
That didn't happen.
So they end up in with about $575,000 a piece out of a $28 million estate instead of 4.9 million a piece. And this is the kind of stuff that sometimes, and I hate to say it, but I'm on record to say it, and that is sometimes probate court looks like a legal scam, because everything that's legal is not necessarily right. By its jurisdiction, it is correct. By the laws that are written, it is right. It is right in the eyes of the legal system that this is the system that we have. But the question is, does it do the families justice when all the fees that are taken from the families become they become the primary beneficiaries. The court system does, and attorneys oftentimes. But the families become the secondary beneficiaries by getting crumbs from the master's table.
Come on.
Of what's left over after all the creditors. And when you have a state statutory trust, unbeknownst to you, you have given permission when you sign a revocable trust to the attorneys to be able to control what happens to that estate so that your loved ones with a will and with a living trust merely gets a first class front row ticket to probate court to watch the show in court.
So in this case, it was interesting because he had hired these attorneys 5 years prior to his death. And so you got to be careful about that, y'all, because what they how they charged them is that they didn't charge him retainers over those 5 years that they were representing him while he was alive. They charged it at the end of his life. And I'm just like, how can it, legally, right? Then all the searching that they had to do because his wife, so now you don't have, so all the searching you got to do, get to the nephew and to the niece, all that time frame, y'all, that's eating hours up.
Billable hours.
Billable hours. Okay, then you got the probate fees and the taxes and hey, they good at itemizing it. Boy, they itemize the mess out of it, right? To say what they spent on it and what the justification of taking this money. And when I tell you guys, that's ridiculous, and that's what happens.
When you saw the itinerary, what did you see?
I couldn't believe it myself. Our client's attorney was there with us. They couldn't even believe it, right? It's because, again, the laws allow them to do that. When you are now passing money to a secondary beneficiary, the fees go up. I want to make sure everybody knows that. That's what happened in this case. They wasn't passing it to a son or a daughter. They was passing it to a niece or a nephew. Okay? The fees go up. We saw attorneys at Comerica Bank, John. Tell us what the manager told us at the Comerica Bank. This is a prime case of how this stuff happens. Because
manager of 2 Comerica banks, and the attorneys came in who were the trustees of that account.
That's right.
And by the way, for those of you who have accounts, make sure that you list someone of viable responsibility to be a successor person or a co-partner on that bank account, as authorized signer on that bank account. Because if you just list beneficiaries, the beneficiaries, when that person dies, the beneficiaries have no right to look into that account, to check on that account. While the banks are under no obligation to tell you what's in that account. And so for that reason, then you have no idea. So in this case right here, she was sharing with me how one of the trustees came by the bank and certainly was able to extract from the bank of $100,000, $90,000 for their legal fees. The family, unbeknownst to them, were anticipating that, they know that mom saved their money and all this, and they were anticipating on getting the fruits of that particular savings. Well, when the attorney came to them and says, you only have $10,000 available to you. Notice the words available to you.
Right.
Not what was there,
right.
But what's available to you. And so what was available to them was $10,000 divided between 3 to 4 or 5 people, 7 people. What was left? Crumbs from the master's table. And so they were wondering, puzzling, well, how is that possible? We know their mom saved it. We had to take the other amount for legal fees.
And see, that's what I was getting back at. Depending on when she brought that attorney on, the way they do it is they do a check-in call every quarter or every year just to check in, and that's their way of saying that they still represent you and they can really still charge you the retainer, unbeknownst to your family. See, when they get that breakdown, what's your family members gonna do? Can they question that?
Right.
They can, but what they gonna do? You question it all you want to, and there's nothing really gonna happen. You gotta be very careful. So this is why the federal trust is so. It's just gonna be a lot better asset for you. We're giving you options. It's your job to choose which one you want. There is a state trust. There is a federal trust, and we told you how to make sure that trust is in the jurisdiction of the federal district so that you can take the benefits of it. Last thing I want to say about the federal trust is that it's just a vehicle that keeps letting us add assets to it. And that's what I like about it. So, I consider myself a young man still, right? I'm going to buy some more assets, right?
Mm-hmm.
Why would I have a trust that I can't add more assets to? I don't even understand how they even sold that to people.
Right.
I don't even know how you
It's
how we bought that, right?
Yeah.
How we bought into that concept.
Yeah, it's under illusion. If I don't educate you, and here's another thing that is so appropriate, but yet inappropriate. What a lot of attorneys do in state tax, and those of you out there living trusts and wills, I have a couple of questions for you. When was the last time you got a call from the attorney that says, we having a podcast or educational section for you to educate you about the living trust and the will document that you purchased that you have? When was the last time that happened? Many of you, I can count when I first got my will many years ago, it had been 30 years. Not a single attorney ever contacted me to see if I had updated my will or anything like that in 30 years before I learned about having the correct type of setup and having a federal trust set up. But no one has contacted me for 30 years. Versus you can't even go 30 hours hardly or 30 days hardly without Succeed contacting you and letting you know that we have a whole educational system designed for you to educate you about every aspect of your trust so that you don't have to be duped, deceived, lied to, the wool pulled over your eyes, or some kind of little side thing going on, psychology being affected. You don't have any of that stuff that you have to deal with. You have straight up truth. An onion is an onion all the way to the core, and you won't find an orange at the end of the journey of that peel back. And so the fact of the matter is that we do assist our clients in educating them, and that's one of the key educations. You don't get educated about that living trust and that will, therefore the less you know, the better it is for the attorneys that have set that document up, because that means that the less questions you ask, that when you die, the questions you didn't ask, imagine the questions that your family member can't ask either, because you signed the document, and all they're going to tell you in probate court is, on paragraph such and such, and page this, that, and the other, this is what they signed right here. It's right here in the document. That's what they signed.
That's right.
And how can you question what they signed when you weren't there for the signing?
Come on.
As a beneficiary.
That's right.
You have no idea. And so the fact of the matter is, you now are at the mercy of, quote unquote, the intelligence of the attorney. And by the way, y'all, this is why some people are intimidated by when they go to a professional like an attorney. And we're not knocking attorneys, because we got
Absolutely
one.
not.
I'm not knocking attorneys, but I'm trying to say to y'all that listen carefully. Many people who acquiesce in what a lawyer ought to know, just like you think that a doctor should know. And that's why sometimes they give misdiagnosis, because doctors can be wrong and lawyers can be wrong too.
That's right.
That's why our old saying says, publishers publish their mistakes, lawyers sue their mistakes, and doctors bury their mistakes.
Wow. Come on, Doc.
What mistakes in your family have doctors buried? What mistakes in your families have lawyers sued? What mistakes in your family have been published? And the fact of the matter is that if your publication is your living trust and your will, that has been published. The publication is not necessarily in error, but the concepts and principles that guide what needs to take place in your estate has been misguiding you to a probate court, to an early lawsuit, and to a point where you will not qualify necessary for Medicaid.
That's it. So the federal trust, y'all, to wrap this thing up, it eliminates basically the four we call the four monsters. Because see, when you're having to bring on an attorney, a state attorney, that's some gray area there about how they charge you.
Right.
Right. So with this federal trust, you have you're the trustee. So that means you don't have to have attorney on retainer.
Right.
But Succeed does that for you. Okay. So we have an attorney on retainer for all of our clients, an in-house attorney that basically allows us to give you counsel through our attorney. So we don't give you the counsel, she gives you the counsel. Okay? That's huge. And our succession plan for all our clients is that to make sure that there's going to be some counsel given at somebody's death, because let's just face it, at the end of somebody's death, somebody has to talk to somebody. Right?
Right.
We know this, y'all. And what's happening to most people is they're having to now go hire an attorney to talk about somebody's death. This is why we're leaving the succession plan for you guys. The videos are not only just for our clients, but our successors as well. All your people that are going to take over your trust, they now have adequate information to go reference to actually guide them through the process. So again, we have thought this thing out. We want to make sure that all of our clients are protected, not only in this generation, but the next generations as well. We thought all of this out. You know, if your successor calls us, we know how to now, comply with your successor. We have series of questions to ask them to make sure who they are. Okay, we're not giving your information out just to anybody. So all that stuff has already been thought out, but we want to make sure that you're educated behind the instrument that you hold. All right, John. So that federal trust, man, is the way to go, in our opinion. But again, you have your right to choose your own type of trust. State trust is only really of them. State trust, federal trust. Most of all the 166 trusts out there are mostly like state trusts.
Right. And what the large print give it, the small print take it away.
Right.
The clauses that don't give you pauses, buyer, you cannot be aware because you don't know what to be aware if you have not been educated. Our people are destroyed because of a lack of knowledge. Need you be destroyed because of lack of your knowledge? Need you be destroyed because you are the person that's the decision maker that will set the tone for the next generation that is to come after you for the next 3-4 generations? Need you be the one that is the responsible or irresponsible one that did not make the appropriate decisions when you needed to seek, as the Bible says, in the multitude of many counselors, there is much wisdom. How much wisdom do you have today to make the most informed decision about your family's estate? We want you to make sure that you can take advantage of our number, 817-302-6777. If you need to have special counsel, you can look at our website, succeedconsultingfirm.com. We have this podcast right here. Every Monday and Tuesday, we have an educational class that comes up that you can come and take advantage of and ask questions from 7 p.m. to 9 p.m. We are making sure that you can be educated to the general public. And all you need to do is go on that website or call that number, and we will make sure you can look at it on the screen that we will have there where you can also access the registration for Mondays and Tuesdays classes. Don't miss them. We may be coming to a city near you.
That's right.
Gather your friends and family together. If you want us to come to do a presentation to your local community, it doesn't matter what state you're in, we'll come to you. We take care of our airfare. We take care of our transportation, our hotel accommodations, and so forth. You have a group of 20 or more, we're coming to help support you in your local community, to help you make sure that your family, friends, and so forth can be educated on these types of things so that you don't have to be duped by the system, because everything that's legal is not necessarily right. And we know for sure that Jim Crow was legal, but it wasn't right.
That's right.
Redlining was legal, but it wasn't right. Slavery was legal, but it wasn't right. A lot of things that are often legal and are residuals of the past laws that have been passed down through the line. Misogyny laws were legal, but they weren't right. So the fact of the matter is, everything that is stated to be legal is not necessarily right in the eyes of the actual application to what it has the effect of for individuals and families to come. So you want to make sure that you have your family educated, and these podcasts are designed.
That's what I was going to say, man. I'm just so glad we're doing this, John, because, man, I'm thinking about my kids and my grandkids. They're going to be able to sit back and watch this podcast, man.
Yes,
Ain't that something, man?
Yes, sir.
Our kids going to be able to watch this. So long to you guys. We're going to come back on the next episode. We got so many topics to discuss, because we're diving deep into this, this federal type of trust. It's not in our vocabulary. No, a lot of people don't know about it, but we want to make sure we change the narrative when it comes to that. So thank y'all for making it your choice to succeed.
Sure.
And we'll see y'all on the next podcast.
Yeah, we want to have a word of prayer with you before we close out. We think that's important for you and your family. So let's have a word of prayer before we close. Father in heaven, we thank you for your loving kindness, your tender mercies. Take the knowledge that we have shared today and all you're getting it in understanding, and with such an understanding apply its principles so that you can have a house built upon a rock and not on sinking sand, so that you can have to live by principle and to live by assignment and by the will of God, not by your own will, but by your seeking the Holy Spirit's information to guide you and lead you in making the right and appropriate decision for your family, so that your house can be sure, your bread and water can be sure, and your estate planning can certainly be secured as well for the future. God, may God bless you and keep you. In Jesus' worthy name, Yeshua, we pray. Amen.
Amen.
God bless y'all. We see you on the next podcast.
Perfect.
about flash. This about foundation.
Yeah. I watched a good man turn ashes to acres, built from nothing, still left it exposed to the takers, paperwork missing. Intentions were pure, but the absence of structure made the outcome unsure. They say hard work is enough, that's a myth we inherit. If wisdom ain't documented, then wealth don't merit. Probate eating the pie, while the bloodline wait. Generations starving off a patriarch's mistake. I don't rap for applause, I lecture in rhythm. Each bar is a brick in the system I'm building. Ownership over emotion, control over chance. A future that's written, don't rely on advance. I speak to the fathers who thought they had time, till the clock made a liar out of hustle and grind. What you leave ain't your money, it's instruction and law. A legacy guarded by wisdom, not flaw.
Build it stronger than you, let it outlive your name. So the love you leave behind don't dissolve in the pain. If tomorrow don't come, let your vision remain. We don't just survive, we preserve the flame. Build it deeper than dreams, let it echo through time. So your children's children know you plant every line. If the world try to take, let it be resistance. This is love and structure, this is legacy in existence.
Intellect sharpened by consequence and cause. I don't fear death, I fear disorder and loss. Seen the states disintegrate from sentiment alone. When attention ain't enforced, it get picked to the bone. You could love your kids loud and still fail them in silence. If you don't get protection, legal defiance. I speak asset allocation, privacy trust. Not paranoia, just stewardship, honor and must. This ain't rich talk, this is responsible living. A will without wisdom is permission for pillaging. I'm angry at cycles that keep us uninformed. We inherit trauma, but never the form. I break patterns with paperwork, planning and foresight. So my bloodline sleep peaceful when I'm out of sight.
Don't leave love unguarded, don't leave hope unplanned. What you build in wisdom still stands when you can't stand. Build it stronger than you, let it outlive your name. So the love you leave behind don't dissolve in the pain. If tomorrow don't come, let your vision remain. We don't just survive, we preserve the flame. Build it deeper than dreams, let it echo through time. So your children's children know you plant every line. If the world try to take, let it be resistance. This is love and structure, this is legacy in existence. Legacy in existence, legacy in existence. This is legacy in existence. Legacy ain't what you leave, it's what still works when you're gone. So are you gonna leave a legacy?